Welcome, everyone. Judy, if you could get us all set to stream. Well, thank you very much. Welcome to anyone out there in streaming land, and committee, thank you for carving out the time for a special meeting tonight. That allows us to keep going. We've got a lot of bills to get through. Tonight, we'll take up Senate File 23 and Senate File 100. Welcome, everyone. Thank you all for being here tonight. We appreciate that. Let's take roll, Judy, and get underway tonight.
Senator Case?
Present.
Senator Cooper?
Here.
Senator Murphy?
Here.
Senator Schuler?
Here.
Chairman Landon?
Here. Thank you, Judy. All the reminders are still pertain. We are streaming. We are live, so be careful with the offline conversations. And let's go with Senate File 23. How would you guys like to come up and walk us through what this bill is doing? That would be terrific. Thanks for being here. Lisa, thank you. For the record, please introduce yourselves.
Mr. Chairman, members of the committee, my name is Elisa Butler, and I'm the State Court Administrator for the Wyoming Judicial Branch.
Mr. Chairman, members of the committee, my name is Ben Birmingham. I serve as Chief Legal Officer for the Wyoming Judicial Branch.
Welcome. Thank you. What are we looking at in Senate File 23?
Mr. Chairman, I'm going to just do a quick overview, and then I'm going to hand it over to Ben to take you through more of the specifics of treatment courts, because he knows them much better than I. What this bill basically does is it transfers the administration of treatment courts in Wyoming from the Department of Health to the Judiciary. So in other words, administration of treatment courts would now fall under the Judiciary after this bill is passed. There are a number of reasons why we support this bill within the judicial branch. The first is that these are courts, and so it makes sense that they would fall under the judiciary. So there's that reason. And then they are also judge-centered. Generally, treatment courts really are driven by judges, treatment court judges in those treatment courts. And a lot of our circuit court judge, and I think maybe one of our district court judges right now, serve as treatment court judges throughout the state. So really, this is what you'll see in the bill, and Mr. Chairman, I can walk you through, although just a simple explanation of the bill itself would be that all of the provisions that currently exist within the title on treatment courts, which is within, I believe, Title 7, is that right? Are just moved from Title 7 to Title 5, which is where the courts live in the statutes. And then the references to the Department of Health or the department are replaced with the Supreme Court. And so I'd be happy to walk through the changes with you, but that really is very simply what the bill does throughout. There are a few, I would say, little pieces that I'd like to point out to you where there are other changes aside from that. So let me just get to those. So beginning on page 13, you'll see one change that is just not basically a language change, and that starts on line 15, and that strikes a sentence that basically limits the percentage of the total amount of funding that the Department of Health uses to administer treatment courts. So it strikes that limitation on the judiciary. I think the reason for that, at least initially, is it may take a little more than that initially to get treatment courts up and running, to get those administered through the judiciary. So we wanted to make sure to take out that limitation. The second piece that I'll bring to your attention is on page 14. And that is lines 10 through 13. Basically what this does, and I know Director Johansson is here, so he and members of his team can speak to this probably better than I, but really we do not want to be in the business. The judiciary does not want to be in the business of certifying providers. That is something that should fall with the Department of Health. We have no expertise in that area. So what this does is it really helps to clarify that certification requirements will be done in consultation with the Supreme Court, but generally they will be done by the Department of Health rather than the judiciary.
Ms. Butler, allow me to stop you for just a moment, and I need to catch up.
Sure.
Give me that page reference one more time.
Absolutely. It's page 14,
Okay?
line 10 is where it begins.
Okay, thank you.
And it's line 10 through 12, basically.
Okay, while we're stopped, committee, any questions thus far? Has anything come up that you'd like to ask Ms. Butler? Okay, keep going. Thank you.
Mr. Chairman, continuing on to page 15, you'll see there's another strikeout on line 2 through line 3. Again, just certification requirements. We would like to leave that to the Department of Health rather than the Supreme Court. And then beginning on line 6 through 10, you'll see another strikeout. So currently there is a panel that this defines. There's a panel consisting of these people defined in this strikeout, or these stakeholders that help determine how funding is going to be allocated to treatment courts throughout the state. I think that panel meets once a year. And so what we have done is we've stricken this for now, just based on the fact that we don't know what this is going to look like into the future. We do anticipate, the judiciary does anticipate, that we will work heavily with stakeholders over the next little bit to help figure out how to administer treatment courts and then the best process for funding over time. But we did not want to be limited again to creating a panel until we have a good understanding of what that should look like. And Mr. Chairman, I believe the rest of the bill, at least in terms of the statutes, really are just changes from the department to the Supreme Court. There are some sections at the end that you may want to bring your attention to. Let's see. So moving on to page 26, section 5. What you'll find there is the actual transfer won't happen until July 1st of 2024. So what we anticipate is over the next year-ish, year and a half, we will work heavily with the Department of Health and potentially with a consultant to help really get our arms around, from the judicial branch perspective, what treatment courts look like in Wyoming, what we need to do to take on the administration of treatment courts, and then also to help us determine what kind of rules we need to put in place and how to make them more efficient and effective throughout the state. So that effective date, or that transfer date of July 1st, 2024 would give us the time to do that. And let's see if there's anything else I would like to note to you. On page 27, section 5, subsection C, that starts on line 18. What you'll find is this is just, again, language as to the transfer. So funding and positions that live within the Department of Health now that are allocated to treatment courts would come over to the judicial branch. And on page 28, section 6, subsection A, which starts on line 7, gives us the authority to begin promulgating rules, which we will do before the transfer date. And subsection C is probably something that you all will be very interested in. The statute, so that's on page 28, line 17. As the bill is written today, this will require us to come back to you in August of 2023 to provide you with a report. So we will consult with the Department of Health over the time. We will create a joint report as to what this looks like, how the transfer is going to occur, so we can make sure that it's a smooth transfer, and we will make it with as as few hiccups as we can along the way. So we will report back to you in August of this year with a plan as to how that transfer is going to occur. And Mr. Chair, I think that's the pieces of the bill that I wanted to point out to you. Again, I would hand it over to Ben. I would stand for any questions initially, and then I'll hand it over to Ben to take you through a little bit more about what treatment courts do and how they benefit the state.
Ms. Butler, thank you very much. We may want to touch a little bit on the administrative impact, not to get too deep into that, because we will certainly have to take this bill in front of appropriations, but it may help our committee up on the floor to get a good sense of kind of what we're looking at. And I'm looking back at the Department of Health too. So thank you. So Mr. Birmingham, go ahead. We're anxious to hear from you too.
Thank you, Mr. Chairman and members of the committee. It's a pleasure to be here with you this evening. As you heard last week, Chief Justice Fox in her State of the Judiciary address remarked that the judicial branch fully supports this bill transferring treatment courts from the Department of Health to the Wyoming Judicial Branch. And what I'd like to do briefly is not only reiterate that support, but also briefly explain why the judicial branch supports this move and this transfer. And we see both structural and strategic reasons for moving treatment courts from the Department of Health to the Wyoming Judicial Branch. And the structural reason, very simply, is that at the end of the day, treatment courts are courts presided over by judges, and courts belong in the judicial branch, not in the executive branch. For sure, treatment courts are unique. They deviate some from our traditional judicial proceedings, where you have a judge and two opposing parties seeking an adjudication of guilt or innocence. In treatment courts, instead of just opposing parties and a judge, you have a team of professionals working together. This team includes treatment court coordinators, treatment service providers, supervision, defense attorneys, prosecutors, and the judge. And they work together to seek to reduce substance abuse, to rehabilitate the offender, and to stop related crimes. While this team is made up of important team members, the leader of the team is the judge. The judge serves as the critical link between treatment and criminal justice. And while these treatment court proceedings feature a much more collaborative and cooperative approach than you'd see in most cases heard in our courts, the cases do bear the hallmarks of a judicial proceeding. So a respect and adherence to the principles of due process, notice and opportunity to be heard, a formal courtroom setting, a judge who is handling the proceedings according to court rules and procedures, advocates, and then a judge who is holding participants accountable under the law, either providing incentives for compliance with program requirements or sanctions for noncompliance. So all of this is to say that while treatment courts are unique, at the end of the day, at their very core, treatment courts are courts, and courts, we would submit, belong in the judicial branch. And this is the reason why we believe most states in the country house their treatment court programs within their judicial branches, not within their executive branches. We performed a review of other states to see how other states handle this, and we only found 2 other states that house treatment courts within their executive branches. And we believe there are structural reasons for this bill. But there are also some strategic reasons. And the strategic reason is that treatment courts are a tool for addressing Wyoming's behavioral health crisis. As this committee knows, Wyoming, as with every other state in the nation, faces a behavioral health crisis. And our judges on the front line see this crisis every day. They see clogged dockets, and then they see the unproductive recycling of the mentally ill and addicted through the criminal justice system. But they also see how treatment courts can stop this unproductive recycling by treating the underlying problems and then stopping recidivism and rehabilitating offenders. So because judges see the impact of the behavioral health crisis, but because they also see the potential of treatment courts to break this cycle, they are fully committed to getting the most out of treatment courts. So those simply are the structural and strategic reasons why the Wyoming Judicial Branch supports this transfer. And with that, I'd be happy to stand for any questions you have about treatment courts.
Committee, questions? Go ahead, Senator Schuler.
Thank you, Mr. Chairman. I actually have a couple questions, if I could. The first one is just really simple. How many treatment courts are there in Wyoming right now?
Mr. Birmingham?
Mr. Chairman, my understanding is there are 19 treatment courts in Wyoming that receive state funding, and I believe these are located in 13 different counties throughout the state.
Follow up?
Go ahead, Senator, you bet.
Thank you, Mr. Chairman. I think they've been very successful in the past, and I don't anticipate that changing. In fact, they could be really probably more effective moving them into the courts. I see where they'll have to have, or you've asked anyway, included one full-time position responsible for administration of the program. What I'm wondering is whoever was responsible for administrating program in the Department of Health, is there any way they could move over without having to hire that extra person? I know that question will be asked, so that's why I asked it.
So, Ms. Butler, you want to take that one?
Mr. Chairman, Senator Schuler, yes, the position will move over. What I would say is we don't know what that position should look like currently, and so I don't want to tell you that it couldn't happen, but we do. One of the reasons that I think we are better suited in the judicial branch to administering the program is because judges are are set in their ways and sometimes are hard to educate on certain areas. And so I think one of the things that we've talked about, and we have an education division within court administration, and we very strategically hired an attorney for that, head of that division, just because we want somebody who is learned in the law to teach judges about the law. That doesn't necessarily preclude that within the administration of the treatment courts, but it is a consideration and something that we would have to think about just in terms of what kind of qualifications we would want for that position. And it will be part of, as I talked about this, getting our arms around treatment courts over the next year and a half and what that should look like. As far as the administration, Mr. Chairman, if I may just to address your point, one of the things that we would like to do in order to get our arms around the treatment courts is to hire a consultant to come in. We have looked at, we've talked with a number of other treatment courts across the United States to determine, what's the best course? What does this look like? And we could spend a lot of time trying to figure that out. But there is a consultant who has, upwards of 25 to 30 years of experience in treatment courts doing data and figuring out the best method. And so what we would like to do is over the next year and a half, work with that consultant to really figure out a plan to move forward. And we have requested funding, ARPA funding, to do that. So we've made a request to the Joint Appropriations Committee for $100,000 in ARPA funding in order to hire that consultant and really take a good look at treatment courts and how we could best administer them. I believe that request has been approved contingent upon this bill passing.
Ms. Butler, just to jump in, I had a hunch that you maybe had a good idea of who might be good help on this front. So, yeah. Committee, additional questions? Senator Furphy.
Thank you, Mr. Chairman. Well, what I thought I had heard previously in the Supreme Court, excuse me, that there's a shortage of judges already in the court system. And this seems like it's going to compound it even more. So I'd appreciate your comments on that.
Ms. Butler, go ahead.
Mr. Chairman, Senator Furphy, so what I would say to that is there are currently circuit court judges who serve as treatment court judges. And so this would not be an additional load on those judges. There is a possibility that we would want to expand treatment courts to locations where they are not currently. And there's also that possibility that we would ask a circuit court judge to step in and be a treatment court judge for that treatment court. I think if we did that, What we would really need to do is take a good hard look at the workload of that judge and determine whether or not it's a possibility if they have the bandwidth to take on a treatment court. And then the other piece of this is in some treatment courts throughout the state, our sitting judges do not act as treatment court judges. We actually have treatment court magistrates that they're paid through a number of different funding sources, some through the treatment court funds that they get from the Department of Health, some through counties. It just depends on the treatment court itself. So there is a possibility to expand treatment courts without adding to the workload of our judges. But I do think we would probably, if we did look at, trying to create or stand up a treatment court in a location where it currently does not exist, we would probably look at the circuit court judge first if they have the bandwidth to take that on. But it would be an analysis as to whether or not they have the time in their workload to get that done.
Senator Furphy, follow up? Okay. Senator Cates.
Thank you very much, Mr. Chairman, Ms. Butler, and thank you guys for being here. I'm kind of interested in this. I'd like to go to the fiscal aspects of it, if we could. I'm looking on the fiscal note in the last page. Looks like, we take 3.3, almost $3.4 million from the Department of Health, and we give it to the Supreme Court. According to this, the Department of Health Agency Fund, it doesn't look like it includes those other sources of funding that we may have talked about, maybe some county funds, maybe there's grant money. So those probably wouldn't be included. I think it's just the agency to the Supreme Court, and I'm okay with that. But I'm not sure how you gather up those other funds and whether they would follow the court, but I guess that'll remain to be seen. I heard you say that the Appropriations Committee has already amended the bill perhaps to have $100,000 for implementation with respect to a consultant. Did I hear that right?
Ms. Butler?
Mr. Chairman, Senator Case, it is an ARPA funding request. So I don't think it would, I'm not sure how it would fall within the budget bill, but it is through ARPA. So it wouldn't be a general fund request. But yes, my understanding is that has been approved by the Joint Appropriations Committee, again, contingent upon this bill passing.
Yeah, and Mr. Chairman, just to go down that a little bit, I think they had their round robin on Friday. And my understanding is there's 3 separate bills that we're going to get regarding budget, and some of which will include, one of which at least will include the ARPA funding. So, that's how I think it's coming, but this will still have to be approved from the legislature. But it is tied to this bill, that 100,000. The other way to do it would be to put the 100,000 in this bill, and then I guess on the bottom line, I'm trying to understand if we should re-refer this to appropriations. Sounds like they're really aware of it, but it might be a good idea for the chairman to talk to the people on appropriations to see if they'd like to look at it. Because there's more moving parts. They may have already know all about this. I think they probably do. But it would be just kind of a courtesy from us to them. And you served on appropriations, Mr. Chairman. I have too. And
Yeah, Senator, that's good stuff. We actually had an offline conversation before the meeting started on that very front. And knowing that they have been briefed in December, and it sounds like even the new Appropriations Committee is pretty aware. But even though this is an administrative impact and just a transfer of funds, I had indicated to our or our Judiciary branch folks tonight that we would refer that. And my thinking was that we would go in front of the Appropriations Committee. But I like your approach too. And, honestly, I've seen it done a couple of ways. We could amend that into the bill just to make sure that everyone knows this is where we're seeking additional funding.
we could let them do that too. They may want to do that.
Correct. And that's exactly where I was going, Senator. So
We're on the same page.
Yeah,
I don't know about gathering up these other funds. They would have ideas about that.
yeah.
They're money-seeking missiles.
Yeah, so Ms. Butler, that gives me a little bit of pause to make sure that all of those funding sources are made available. You referenced magistrates and others that, I assume it's retired judges who come in and help out and you have funds to, I don't know. How does that work? And how do we make sure that all that funding comes with?
Mr. Chairman, that works in a couple of different ways. So generally, if a sitting judge, so a circuit or a district court judge within a county does not act as the treatment court judge, then a magistrate can come in and do that work. Generally, it's an attorney who comes in, not necessarily a retired judge, but an attorney, and they will come in and act as that treatment court judge. They are paid through a number of different methods. Some are not paid at all. It's volunteer. Some are paid through the county. So the county actually provides the money for that. It all is, and let me back up a little bit. We actually pay all of those invoices through the judicial branch simply because of separation of powers and they're acting as judges and all of those kinds of things.
Sure.
But I'll give you one example. Albany County has a juvenile treatment court, and they have a treatment court magistrate who runs that, not a judge, a sitting judge in that county. And the county funds the entire cost of that treatment court magistrate. And so what generally happens is we have an MOU, the judicial branch has an MOU with Albany County. They pay us that money and then we pay the judge that money. So we act as a pass-through for that money. We also have some money in the judicial branch and our branch-wide resources budget to pay treatment court magistrates if needed. I would tell you it would not be enough to pay all of the treatment court magistrates across the state.
Gotcha. That magistrate over in Albany County is not Senator Furphy, is it? Just wonder. Additional questions? Senator Case, any follow-up? You good?
I'm good. Mr. Chairman, I think we could get some help from appropriations and make sure that this has smooth sailing.
I do too. Senator Furphy.
Thank you, Mr. Chairman. I'm interested, looking at page 26, items 16 through 20, where it says the court supervised treatment program. That sounds to me like a treatment program. Someone has to monitor that. I would assume previously that's been done in the Department of Health. I don't think a judge would necessarily want to follow up with a treatment program. So that make sense for the courts to deal with this? Thank you.
Ms. Butler, do you want to try that one or?
I will try. I don't know that I will be successful, Mr. Chairman, Senator Furphy. So it's the court supervised treatment program, and that is the treatment court program, essentially. So that program, agree with you 100%. The judiciary does not want to be in the business of providing any kind of oversight over providers themselves. Again, that is not where we live. That's not where we have the expertise. Very clearly, the Department of Health has that kind of expertise. So judges would not, while within treatment court programs, they do basically order participants to get certain kinds of treatment, right? They say you need to go get substance abuse treatment of some sort from a provider. So they can order that of the participant, and then the participant will use a provider through the treatment court to get that kind of treatment. And so that would really be the where we would want to stay, is the ability to order the participant to basically participate in treatment, but then the certification, the oversight of the provider itself would not be done through the judiciary. It would be done through the Department of Health.
So, Ms. Butler, and I think that's the references in the bill where you indicated that we are leaving language in that involves our agency folks, and we'll hear from them here in just a little bit. But Is that not the case?
Mr. Chairman, that is the case.
Anything further, committee, for these two folks? Stay close by. Thank you again for being here. I'm gonna ask our folks from the Department of Health. Good to see you, gentlemen. Thank you for being here. Mr. Johansson, thanks for being here tonight. And
Good evening, Mr. Chairman, members of the committee. Stephen Johansson, I'm the director for the Wyoming Department of Health, joined by Matt Petrie to my right, who is the senior administrator of our Behavioral Health Division, which currently oversees the court supervised treatment programs. Mr. Chairman, I'll be brief. Ms. Butler did a great job walking through the bill. I will say that over the course of the last interim period, we had a lot of conversations at the Judiciary Committee and a lot of conversations between the Department of Health and the judicial branch and the Supreme Court to look at making this work successfully. I think we're all on the same page that with these programs, we want them to operate not only efficiently, but effectively as sentencing alternatives for the folks that go through the legal system and have these types of needs. I'm comfortable that we have worked through the vast majority of those issues. A lot of that is reflected in the bill here. Ms. Butler mentioned a few of them, like the delayed effective date. I think that makes sense, not only for the time to make this transition and implement it, but it aligns well with the close of the current biennium. So the budget transfer and the positions that will be that will be very, very clean. I will close, Mr. Chairman, by saying that I've had quite a few discussions with Chief Justice Fox and her staff on the behavioral health topics in a variety of different ways, and I trust her implicitly. I appreciate her commitment to tackling a lot of these issues, especially from the legal system perspective. I'm very optimistic that through partnerships between branches, we're really setting the state up for a lot of success in this particular area. The partnership between the Department of Health and the judicial branch through this bill will not go away. You see that both mechanically and for example, through the Department of Health continuing to certify providers. Also through just this transition, we will likely have to have memoranda of understanding and things of that nature. And again, couldn't compliment the Chief Justice and her branch more on her commitment and their commitment to improving behavioral health for the residents of Wyoming. With that, Mr. Chairman, Mr. Petrie and I are here to answer any questions you might have about the current operations of this program or content related to the bill.
Director, thank you. It sounds like you have no intention of letting up on the accelerator. From your standpoint, everything's covered in the bill in terms of working together with the judiciary branch?
Mr. Chairman, that's right, both in this topic and again, as you all know, we've reconstructed some of our safety net behavioral health facilities. You all in the legislature, in partnership with the executive branch and providers, we've started the process of a significant behavioral health reform in our communities and for clients that we know need better services and outcomes. This is another piece of that, I think. And I mentioned before in the interim that from a certain standpoint, I'm agnostic of where programs like this live, as long as they function effectively and efficiently. And I think we can make that happen here.
Thank you very much. Committee questions? Senator Schuler.
Thank you, Mr. Chairman. Yeah, my question is basically on the certification requirements. I'm kind of wondering if that, is going to be a hardship for you guys. And also, I just want to know if maybe how much you would reach out to our community health centers for help in that area.
Go ahead, Director.
Mr. Chairman, Senator Schuler, it's a good question. That doesn't give me much heartburn there. Again, as Ms. Butler mentioned, it's something that we do for community mental health centers or mental health providers that operate in this arena. So it's not too much of a change for us. So no major concerns there. And then as I'm sure someone behind me will speak to, who lives in this world also as a provider association, this is just a world that we live in, whether it's certification of providers, different accrediting standards. You all know the Department of Health is a big animal. So we have a certain level of operational expertise in a lot of different provider certification, survey, compliance, that type of thing.
Follow up, Senator? Any other questions of the Department of Health? Senator Case?
It's, as we go forward, the management and connection of the program and the support, how is that administered? Do you have like I assume folks get together once in a while, or there a relationship between the court and the department? Just, I don't have any idea how that works.
How's that liaison how's that gonna look?
Mr. Chairman, Senator Case, it's another good question. The way I see this working is both addressed in the bill, and I think I can speak to those items that aren't. Obviously, there's in consultation with the Supreme Court, we will continue this certification and more regulatory role. I see that both as informal and potentially formal. Given that this is a year plus in transition, we've discussed with the judicial branch of what, again, an MOU or a memoranda of understanding would look like, so that we can codify and formalize, whose duties are whose. That's something I would certainly want to have, so that if there's, an administration or staff that don't have what I would describe as a very good working relationship between the branches in the future, that could happen, that we have some of that memorialized. So I see that both being, again, informal, but also formalized through agreements.
Follow up, Senator?
Well, Mr. Chair, I'm just thinking about it. I can see some advantages. I bet judges they probably love you dearly, but they'd probably prefer to be in the court system. I'm just guessing that.
Mr. Chairman, Senator Case, that's a nice way to put it, so thank you. As a Chief Justice mentioned to me when we started having these conversations, to put it bluntly, she said, I think I carry a little more weight with judges than you do, and she's accurate there.
Mr. Petrie, it's good to see you, by the way. We go all the way back to community college days. Thanks for being here.
Good to see you as well, Chairman.
Do you have anything you'd like to add, Mr. Petrie, before we move on to some other folks?
Mr. Chairman, I do not.
Okay, all righty. Director, thank you for being here. Please stay close. Oh, Senator Furphy.
Thank you, Mr. Chairman. Well, I think you're making me feel comfortable. When I first read through this, on page 28, section 6, it says, line 7, the Supreme Court shall promulgate all rules necessary to implement and manage the court supervised treatment program. If I'm understanding what you're saying, is you're going to have input on all of that area to the Supreme Court. My concern was I didn't know that they might not have the expertise to develop the rules to manage that area. So thank you, Mr. Chairman.
Director, go ahead.
Mr. Chairman, Senator Furphy, good point. And two things that I would say there. One, on really the provider side. So your question earlier was about these are treatment courts. These have treatment programs. And it's really two things operating. One is the legal system, and that's the courts. And again, you heard the judicial branch speak to that's what they do. But what this is a sentencing alternative is then those treatment court programs have contracted treatment providers that then provide the service, substance abuse counseling, medication management, different types of programming to the recipients that are going through the program. That's where I think Department of Health continues to have a role, is making sure that our providers in that system have certain quality standards, have certain, licensure, accreditation standards met, so that we're also providing high quality and safe care to these folks. And this bill really does articulate that the Department of Health's role continues there. In terms of the Supreme Court's rulemaking authority, when this would take effect about 18 months from now, if it were to pass, whether judicial branch wants it or not, they'll get feedback from me, from the department, whether that's through the public comment process. But I have no doubt in my mind, again, with the trust I have in Justice Fox and her staff, that input will be welcomed. as I mentioned before, and I mentioned to the previous interim committee, whether the programs transfer or not, we all want the same thing, and that's we got folks that go through the legal system that have significant needs, and we want to make sure whatever agency is administering or involved that we're providing the best quality service there. So you certainly have my word that we'll be as involved as we can to make sure the transition goes smoothly and that the program operations are stood up to be even as effective or more effective than they are today.
Director, thank you for being here. Really appreciate it, and please stay close by in case we've got another question we might fire at you a little bit later. Thank you. Appreciate it. We're going to go to anyone else who would like to testify on the bill. Please come forward. Commissioner, welcome. Good to see you.
Chairman, committee, thank you very much for having me today. I'm Gunnar Malm. I'm a Laramie County Commissioner, and I'm here to speak in favor of this bill. It's very exciting. We kind of started working on this last year with the joint interim, and it's exciting to see the work continue. I just wanted to speak to you as not only a county commissioner that sees these programs work in our community and finds them to be financially responsible, but also morally prudent. They really do a great service in our communities and help change lives. And so I wanted to just address the program's success and note that I think that they can continue to be expanded and do even more throughout our communities with their move to the Supreme Court and that added credibility of Chief Justice Fox, First Department of Health. No offense to the good director of Department of Health, but I think that they can really be expanded. As was mentioned, Albany County has a juvenile services court. Laramie County does not, but we operate a veterans treatment court. It's wildly successful. It's not one that we necessarily pay a magistrate for. We actually have found a retired JAG officer that comes in and acts as our magistrate, and so we're able to facilitate the program that way. And so there are people in our communities that want to participate and want to help these programs because they see them work. We also have a great treatment court circuit judge in Judge Chambers that this is really his passion as well. To address a couple maybe of Senator Furphy's comments, Mr. Chairman, I think maybe that link between the judiciary and the treatment section is that we have treatment coordinators that are county employees that facilitate these programs. So they're kind of that bridge between the judicial branch, the treatment branch, and making sure that the participants are getting where they need to be, checking all the boxes of the treatment component, and reporting to the whole treatment team that is the prosecutor, judge, defense attorney, and such. And so I think that if that alleviates some of your concern, those people are in place. They're parts of the county government already. And I know that all of them that I've spoken to are excited about this change as well and what it can mean for the future of treatment courts in our community. And lastly, I'd just tell you, I'm excited and passionate about this subject because I myself am a person in long-term recovery. Actually, thanks to Facebook memories, I can tell you today, 8 years ago today, I walked out of a rehabilitation facility in Colorado and now sit here talking to a bunch of wonderful senators about a program that does wonderful work in our community. So recovery is possible. It can provide great lives to a vast majority of residents that encounter the legal system through addiction and mental health crisis. And we can provide them the resources to pull them out of that. And we have seen it work in our community. So I'm personally excited about this and hope that the committee continues to look favorably upon it. So thank you.
Commissioner Baum, congratulations. We're proud of that. Very proud. And thank you for being here. Questions for the commissioner? Thanks again, Commissioner. Appreciate it. Good evening.
Good afternoon, Mr. Chairman, members of the committee. I'm Andy Somerville. I'm the Executive Director for the Wyoming Association of Mental Health and Substance Abuse Centers, commonly known as WAMSAC. And I just have a few comments for the committee today. So first, I'm going to start off with saying, when this idea came before us, we certainly had some questions from the provider point of view. What we've encountered over conversations and work in the interim is what I think is going to be a wonderful working collaborative relationship between the Department of Health and the judiciary. There's a lot of passion to make those programs better and potentially, move them into new areas in the state as we can find funding to support all of those things. And so we're really excited to have the judiciary at the table and as part of those conversations. As a mental health provider organization, we cannot understate the importance of the Black Robe effect and the judiciary's importance in dealing with numerous types of mental health cases, this just being one of them. So one of the issues that I wanted to, or not issues, but one of the things I want to let you know is that the community mental health centers right now run the programs in 6 out of the 13 counties that are there. Primarily, we run the 3 smallest county programs. They're very rural, small counties, and where mental health resources are more limited. We imagine that will probably continue to go in the future. And as the director, as Director of Department of Health, touched on just briefly, as we're moving through behavioral health reform, we see this process as, again, dovetailing nicely as we've worked through previous legislation with House Bill 31, which was criminal justice, mental health related reform. We're doing behavioral health reform. Now we're doing this, trying to bring all of these pieces together to make sure that we're really covering any gaps. And so we see that that's a very positive thing, and we look forward to that. And I do have one requested technical change to the bill that I have run by the judiciary, and I let the Director of Department of Health know about 20 minutes ago when we started the meeting. On page 14, it is on line 12. It says, it's the sentence that says 4 certification requirements for treatment personnel. This piece that the Department of Health is managing the providers and the certifications is incredibly important to us. This is a very vulnerable population. We need to make sure that they're getting the best care that we can possibly give them. And so the requested change that I have is to, after the words for certification, add and accreditation. Certification and accreditation are 2 different things, but they are both vastly important, again, in ensuring the quality of care that folks will receive. We look forward to working with the Judiciary and Department of Health over the next year as they work on looking at the programs and seeing what else could be done. But in terms of rule promulgation, it seemed prudent to add that to the bill now, as opposed to maybe bringing a cleanup bill next session with trying to get it going July 1, 2024. So we stand in full support of the bill, and I'm happy to answer any questions.
Ms. Somerville, you never even looked at a note. That was very well done. I didn't catch you. You indicated how many of our community health centers are involved here. Can you give me that number again?
Mr. Chairman, it is 6.
Okay.
6 out of the 13. And I would just add, if it's permissible, the counties that we operate in, they're the tiny ones. It's Bighorn, Washakie as one entity, Johnson, Lincoln, and then we've got 3 of the bigger counties, not the large, like the medium ones. So we make up that kind of bottom end of the scale where maybe the county can't hire an internal provider, or there's not a private provider that they're contracting with.
Thank you very much. Questions? Senator Schuler.
Thank you, Mr. Chairman. Just a quick question. Do you see any downsides of making the transition over to the court system versus, where you've had the direct correlation with DOH? Do you see any problems with that?
Mr. Chairman, Senator Schuler, we're hoping, right, that everything goes well. Certainly, there's always some concern about change. It's been operating under the Department of Health under these program guidelines for a number of years. But in talking with the centers and, their elected officials on the ground there, what we mostly see is opportunity to improve what we have, potentially look for additional funding sources, and figure out how we can bring more of these programs online, because we do know they're effective.
Thank you, Ms. Somerville. Appreciate it.
Thank you, Mr. Chairman.
Okay. Further testimony on this bill? Good evening. Senator Case. Absolutely. No problem. Good evening. Mr. Winnie. It's good to see you.
Good evening, Mr. Chairman. Bill Winnie, Sublette County. I'm here speaking for myself, but I would note for the committee's information that I was recently brought into the board of the Wyoming Veterans Legal Assistance Group. I support the bill, and my observation of stuff that I've been connected with the Veterans Legal Assistance it is fundamentally a judicial kind of thing that's being done here. It started out as a healthcare kind of thing. That's why it started out over there in the Department of Health. But if you look at what's really going on, I think it's fundamentally a judicial kind of thing. If you look at veterans, and I'm talking a subset here, I guess, of veterans, to my knowledge, there's 3 veterans treatment courts. One of the reasons they brought me into that board is they want more exposure on the western side of the state. But you have a continuum of behaviors with veterans. They come out and they have a problem dealing with the dishonesty in the civilian world. And you get a continuum behavior. On one end, you have the veterans that are committing suicide, 22 per day, or substance abuse, or those kind of things. Those veterans internalize that problem area. Other veterans externalize it. You get into the homeless and then the petty crime and then perhaps some more significant crimes. And so it's a continuum with veterans. And at the end of the day, the question you're dealing with here is how do you dial down the legal power that you put on these people and dial up the treatment? But at the same time, whoever's administering it, a magistrate, needs the ability to hold somebody's feet to the fire. And that's why I think it belongs in the judicial side of things. And so subject to your questions, thank you.
Mr. Winnie, thanks. Any questions? Okay, thanks, Mr. Winnie, appreciate it. Further testimony. Further testimony, please come forward. Gordon, good to see you, Director.
Mr. Chairman, Senate Judiciary Committee, my name is Dan Shannon. I'm the Director for the Wyoming Department of Corrections. Thank you for having me. I just had a few comments. With regards to the Veterans Court, treatment courts, the different specialty courts across our state, it's one of the few alternatives the Department of Corrections has for incarceration. And frankly, we'd be overrun without these courts. We don't just sit back and ask to be a recipient and look at it. We're actively involved. We have 14 agents to provide supervision in 9 counties. We do believe that the nucleus of the judiciary process and the nucleus of the judge would provide more consistency across the board and also provide us an opportunity possibly to expand in the future to assist. It's a 3-part system with the courts, the treatment aspect, and we provide the supervision to our parole agents. And we provide supervised oversight through a risk assessment, and that's how we support these courts. And with that being said, I just can't emphasize enough that the support and how the Department of Corrections would be overwhelmed without this type of process. And as I assured our Chief Justice, and I will this committee too, we will be supportive regardless of the outcome, but we will be supportive if it goes to the judicial branch. And we'll provide the same support and assistance to the courts. And I stand for questions.
So, Director Shannon, I've had the privilege through the years of serving on a couple of task forces in your neck of the woods. It was eye-opening. It was overwhelming at times. And one thing I learned that startled me, even though I knew it was a factor, was the huge percentage of your inmates in the correctional system that are there because of this, because of drugs and alcohol. And it's a big, big number, isn't it?
Mr. Chairman, committee members, it's in excess of 75%, as well as the behavioral health and dual diagnosis with mental health.
Yeah. Director, Senator Case has a question. No, I didn't touch that. Oh, no, that's all right. No, not at all. You didn't. So,
well, and Mr. Chairman, I think it's an important piece of that is many times, and I remember from my days on judiciary before, a long time ago, it's the parole revocations that are often technically connected. I mean, they're technical violations, not necessarily a new serious crime, but they violated the terms of their parole with respect to substance abuse or alcohol. And I'm not quite sure, I think during that period that we're talking about, they would be under the jurisdiction of this court, I assume, but I don't know that actually. So well, I guess that's a good question. Maybe it's not a good question, but would this affect and allow us to improve the area where we're having so much trouble with revocation?
Mr. Chairman, Senator Case, those revocations with the drug and alcohol are in excess of 45%.
Yeah.
45% of our caseload, and it would only increase dramatically without the access to these courts.
Yeah.
Absolutely.
Thank you.
Director, thanks. Any other questions of Director Shannon? Really, really appreciate you taking the time tonight, Director. Appreciate it. And I'm excited about the opportunity ahead, and you're going to play a big role there. So
Thank you, Mr. Chairman.
yeah, thank you.
Thank you.
Any further testimony on Senate File 23? Please come forward. Good evening. Thank you for being here.
Thank you. Thank you, Chairman Landon and members of the committee. My name is Jen Davis. I'm the Governor's Health and Human Services Policy Advisor, and I am here on behalf of our office to support the transition of the move from the Department of Health over to the judicial branch. Governor Gordon is dedicated to working with the three branches around mental health and substance abuse, and is in support of this move to ensure that the judicial part of this continues to grow and provide additional access to the residents of Wyoming that need these courts. And it being a court system, we do really think it's essential that the work continues to partner with the Department of Health for the behavioral health components of it, but we do stand in support of this. So happy to answer any questions that you have.
Ms. Davis, thank you. Any questions, committee? All right. Thank you so much. Really appreciate it. Further testimony, Senate File 23. Anyone else in the room? Okay, Judy, have we had anyone appear online tonight?
No, Mr. Chairman.
We had nobody before the meeting? Okay, I'm going to close testimony on Senate File 23. What is your pleasure, committee? Moved by Senator Case. Let's work the bill real quickly. There's at least one suggested amendment, and anything else that the committee might have. Specifically, I'm referring to page 14. I think we were encouraged to consider something there. Senator Case,
Page 14, line
want to
12.
remind us what that proposed amendment would be?
So it's on page 14. It's in the last, second to the last sentence. It's on line 12. After the word certification, add, insert, and accreditation.
Okay, discussion. All in favor of Senator Case's motion, please say aye.
Aye.
Any opposed, no? That amendment has been adopted. And Judy, did you get that okay? All right. Is there anything further? We won't go page by page. Anything further in Senate File 23? Any further discussion or comments on the Senate file? Are you ready for the question? Okay, Judy, please call the roll on Senate File 23.
Senator Case.
Aye.
Senator Cooper.
Aye.
Senator Murphy.
Aye.
Senator Schuler.
Aye.
Chairman Landon.
Aye.
Mr. Chairman, Senate File 23 passes with 5 ayes.
Thank you very much, everyone. With regard to Senate File 23, appreciate your time, your effort. Really look forward to this rollout. Director, thank you for your commitment. Ms. Butler, and thank you so much. Look forward to working with all of you. Commissioner, thank you very much. Okay, we've got a second bill, Senate File 100. I was going to bring forward the good representative from the interim committee who is still on Judiciary on the other side. He made a brief appearance here, but he has
Here they are.
there they are. There's one. There's one. And by golly, Senator, we're ready for it. Is the representative, okay, no problem. Is the representative still out there? I noticed
Mr. Chairman, yes. I can grab it.
Representative Craigo did, and I was going to see if he had any thoughts he'd like to share. Representative, we were just going to recognize and appreciate you for stopping by this evening. Did you have any comments or thoughts on Senate File 23? We have just passed the bill out of committee, but we would value anything that you have to offer.
Senator Barlow is the
Yeah, I was just going to back up for a moment, Representative. You were involved in the interim work on that bill, and it's good work.
Thank you, Mr. Chairman. I did not stop by to comment on that, but I'm happy to do so. I think it's a good idea. You know, at the end of the day, the courts are really the ones closest to the problem. They're also the ones closest to the solution. And in our county, I know we use that system a lot, and it is very successful. And I think there's some opportunities maybe to find additional funding to grow the program. It hopefully no cost to the citizens of the state of Wyoming even. And I think that's one of the benefits of making that transition and really getting the judicial branch more involved in that process.
Representative, thank you. I didn't mean to catch you flat-footed or cold on that one, but thanks for your comments. I'm excited to move that bill along, and hopefully we'll get it over to your side soon. Senator, thank you for being here. I was actually going to text you when we were ready, and you've been here listening in on the other one. Appreciate that. Welcome.
Good evening. Good evening,
committee. Let's hear about Senate File 100.
Thank you, committee. So Senate File 100, I mean, it's pretty direct what it is. It's about not allowing ex-spouses or through a divorce or annulled marriages to inherit things that you would not expect them to get. And I'll walk you through the bill. And this bill came to me, it's kind of modeled after some legislation that's in a neighboring state, and multiple states have done this. We currently have a law in the books that really deals just with wills or probate, not with things outside of that. So you will see this bill has a repealer in it. And certainly there's Representative Craigo here. There are some folks from the financial institutions here who say, well, what about this? There are some circumstances that maybe I will not know the answers to. I have thrown out a lifeline to former Speaker Lubno, who was one of the ones that brought this to my attention. This bill was actually introduced in 2019 while I was in leadership in the other body. And it was one of those bills that just didn't make the cut when we were prioritizing bills at that time. And then we went into some other public health challenges, and it was a lower priority. So it's come back as an interest. The good Chairman Nethercott, former chairman of this committee, actually reached out to me about a month ago and said, I think we need to bring that back. I'm hearing about this issue more and more. So the bill is actually revived. It's a bill that was not entertained, but written several years ago with a few little modifications. So, Mr. Chairman, if you'd like, I'll just walk through the bill.
Senator, that would be great. And boy, you're right. We did have our hands full the last couple of years. So,
yes, sir.
Yeah.
So I think that the long title, I mean, I think does a very good job of summarizing it. And you'll see that's wills and probate, and then the line 2, probate and non-probate transfers, which, as I mentioned, is my understanding different. Talks about divorce and annulment. So basically, when anytime there's a marriage comes to an end through either process, and then of course you have to get rid of the repeal of the existing language. So and it's a new section of law, also within Title II, but certainly you start off with the definitions. And my understanding is this is very, at least my understanding is this is very, I wouldn't say boilerplate, but it's more model type language or understood language from other states. probably the line 3, page 3, line 4. And this is talking about instruments that were revocable, meaning that the individual has the opportunity to change them at their leisure. And so I think that is key to this discussion. And then as you go through, page 4 talks about what this bill, if passed, would revoke. And then it's basically 4 different categories in total. So you'll see property on line 3 of page 4. You'll see an appointment or disposition. And to me, that would be like a medical power of attorney or something along those lines. And certainly there's others in the rooms that maybe have better or other examples. And then in subsection C, special power, and actually this is where I'll have to throw out for a lifeline if somebody wants to help with that, but special powers. And then D, fiduciary responsibility. So maybe that would be a power of attorney or something like that. The question will come up, I believe, from some folks in the room. It's already come up, and Senator Nethercott and I are both looking at it, is what does this mean for bank accounts and things like that. I think that's answered on a subsequent page, but we'll get to that. The one thing I think I am understanding from visiting with different folks is it really doesn't change much of what already occurs in the law. It just clarifies it and puts forth on the non-probate side of what might occur. Let's see. And then you get into page 5. This actually talks about what is occurring is revoking. First of all, page 4 revokes any revocable. And then on the top of page 5 is severing the interests in property, continuing that. And this is where the attorneys really do, I really will need a lifeline. It talks about, severing this pair and becoming tenancies in common, meaning both individuals would have this, my understanding, both have the same access to the asset. It wouldn't be joint. I mean, it would be, they could both do something as individuals. This is page 5, lines 9 through 19. This talks about if there are debits, if you will, or creditors that have an interest in something, this does not relieve these people of those. I mean, they still have that obligation. They don't get out of it because there's a divorce and annulment. They still owe what they owe. That would be with some exceptions that they could on page 5, line 14, unless in writing declares a severance is noted, meaning one person says, I accept all of the liability that is incurred or through this. The next page is, page 6. I think these are mostly just cleaning up some things. And then you get to section 2, which is the repeal, and that's the current language. I do have the current language with me. And as I said, Mr. Chairman, this language is at least my understanding from listening to a couple other folks, this has only to do with probatable issues, not ones that would be outside of a will. So, Mr. Chairman, effective date, that's it. And like I said, this is not my area of expertise. I was asked to bring this because of actual circumstances, and you've probably heard of some of these stories. Somebody passes, the ex-spouse gets the benefits, and the kids may get nothing because there was a life insurance policy or a death benefit or a something that didn't get executed or didn't get changed and left, and anyway, went to a place where you could imagine that maybe the decedent didn't want it to go, or the divorced, the person who was in the divorce did not want it to go, and then subsequently passed. Yeah, and I apologize for maybe getting the order wrong. The death occurred after the divorce. Anyway, and so that's kind of what has brought this to light in several instances.
So, Senator, interesting. I've read a story not long ago about a gentleman that you and I were old enough to enjoy. During the 70s, there was a radio program America's top 40.
Casey Kasem.
There you go. He actually, upon his death, his wife got everything, the kids didn't. Is what brought that to light. But anyway, it's exactly as you just described, Senator. Thank you for walking us through the bill. Any questions of Senator Barlow? We reserve the right to come back to you.
Yes, sir. And Mr. Chairman, to be clear, I did throw out a lifeline to both former Speaker Lubno and Chairman Nethercott, and they're both taking a look at a couple of questions that we've received. And I certainly, as those concerns come forward, want to assure you that we will try to get our hands around better understanding the implications. Thank you,
Appreciate
Mr. Chairman.
that. Yep, we can certainly
Can I-
work
can I ask one
this on the
question?
fly. Senator Case.
Thank you. I'm guessing that there is some mechanism that someone could have to actually leave that person in their will. I mean, I'm sure maybe you did talk about it, but not all these things are scorch and burn.
Thank you, Mr. Chairman, nor death. And that would be page 3, line 16, and that is accounted for in there. Express terms governing provide for the disposition to the former spouse,
Okay.
et cetera. So it absolutely recognizes that there may be amicable circumstances where they do want to have something, but I think this is trying to get to those circumstances where there is no guiding document or there is no acknowledgement, whether it's in the divorce decree or in some other instrument that would be binding on the parties. Thank you, Mr. Chairman. And I apologize for not mentioning that as I went through. My apologies, Mr. Chairman.
Senator, you can certainly stay put. Others can come forward. Oh, Senator Furphy's got a question.
Thank you, Mr. Chairman. I'm curious about how do you deal with children in this situation? If the couples have children, what happens? Thank you, Mr. Chairman.
So, Mr. Chairman, Mr. Chairman, thank you. And so this bill would have no impact on the parental rights or anything like this. This only has to do with those revocable instruments that the two parties would have been in and that may survive, if you will, the divorce and or annulment. It would have no bearing in the anything to do with custody or anything like that, Mr. Chairman.
Okay, thank you. Any other questions? Okay, Representative, would you like to say anything on the bill yet? Or once again, appreciate you coming by and being here.
Thank you, Mr. Chairman. I don't know if I have a whole lot of anything to add that's going to be super beneficial. I've actually been involved in one of these cases as a litigator. This exact situation arose, and it would have been helpful to have a statute. At that point, it would have saved us all a lot of headache, money, etc. The litigants ended up spending a lot of money to sort out who actually got what. Often this happen. Often what happens is people, divorce spouses, forget. They actually settle. Maybe they actually settle in the divorce who gets what, but they fail to follow through, as often a lot of us do, and they don't fill out the appropriate paperwork. They don't change the beneficiaries, for example, on their life insurance policy. This helps in that situation where you just point blank don't remember to change the beneficiary. And so then the people who should have received it as the secondary beneficiaries, for example, kids or something, would end up getting the benefit rather than the divorced spouse whose name was actually still listed on the policy. That's just one example, but that applies generally to a lot of these types of situations that we're trying to solve. And for example, land, if they owned land together, but they didn't really split it up, no longer are they tenants by the entirety. So, or with right of survivorship, they are now just plain old joint tenants. And so if one of them passes away, they can will that or give that. Or if they have no will or trust or any sort of estate planning, it will go according to law. So I'm happy to answer any questions that you may all have, but other than that, I think the good senator did a very good job of explaining what the bill does.
Thank you, Representative. Any questions of the co-sponsor? Senator Cate.
It might be kind of technical. I think in the old days, people used to sign as, and I get my tenancies mixed up, but I know joint tenancy is where that interest can be passed on, and maybe it's tenancy in common. I'm not sure, please. But they used to actually sign that way as Mildred and George tenants, in meaning that they both own the whole. If that is signed that way, would this bill supersede that?
Representative?
That's
You know what I'm talking about?
Mr. Chairman, Senator Case, I do. And my understanding is that is the point of the bill, yes. So that if following the divorce, the appropriate paperwork isn't done, exactly the same for insurance. If it's not done on land ownership, for example, they're, let's say they own a vacant parcel. Houses usually get dealt with because somebody is no longer living there. But let's say they own a vacant parcel or a vacation home or something, and a week after the divorce, somebody dies, it doesn't automatically go to the person who had just divorced the decedent. And so, yes, it would override that. And just for the benefit of the committee, you have joint tenancy with right of survivorship, which does not require marriage. Joint tenancy. Then you have tenancy by the entirety, which is essentially the same thing as joint tenancy with right of survivorship, except you have to be legally married, but has the same benefits. And then you have tenancy in common, which there are no death benefits to any of the owners. And that's the difference. And so anymore, most, and I think there's actually a bill coming that you'll probably get to see that one as well, dealing with how we record that on deeds and the language that we use and exactly what it means. Because as a lawyer, we draft lots of deeds. They will have husband's names, wife's name, and then followed by the language husband and wife. Sometimes we include the words tenants by the entirety, sometimes we don't. So I've always understood if you use the words husband and wife, that means tenant by the entire tenancy by the entirety. I think we're going to have some more debate about that coming up, Senator, but hopefully that answers your question.
Thank you.
It does, and it makes me think, I'm really glad we have people like you, Representative, who can represent some folks in situations like that, because it can get complicated. Yeah. Thanks again for being here. Let's go to anyone else who would like to testify on Senate File 100. Meyer, good evening. We know who you are, but please introduce yourself just for the record.
Mr. Chairman, Scott Meyer on behalf of the Wyoming Bankers Association. As you probably know, I am also an attorney and I do practice, and I think Representative Craigo did a great job of explaining some of this. I just finished a case, a probate up in Fremont County that was a very sad situation where a man committed suicide, but did not get everything done with respect to his divorce that he was instructed to do. So we had real property, we had personal property, we had everything held jointly, what have you. One of the biggest questions that I have on this bill, and we certainly don't stand either in support or in opposition to it, just a lot of questions, but one of the issues I ran into was the pay on death counts. So clearly, if somebody was supposed to take them off, they didn't. Then the ex-wife ended up picking up a whole lot of money, which was to the detriment of the children and everybody else involved. So I don't know how that works with this. And I did look at the other bill from our neighboring state from which this was drafted, and it's not any clearer. I just think there's a lot of uncertainties that I think would bring to the banking industry and probably any other financial institution of how we deal with that. Certainly think it's a great idea from an attorney standpoint. Like Representative Craigo, we've dealt with these things. They are a nuisance. They are expensive. They consume emotions and time and money and everything that goes with it. So I think it's a good idea. I'm just not sure at this point in time how these things work. And I think that's what I'd like to leave with the committee with, is how do we deal with some of those Like I say, pay on death accounts. We're doing a lot of transfer on death deeds. How does that work? Do they presume somebody is going to survive them? It's going to go to that one person that's left on a transfer on death deed or pay on death account? I don't know, but I certainly wouldn't want to have to start guessing.
So go ahead, Senator Case.
We've worked very hard to include pay on death things for different things. It started out as bank accounts, but it is expanded. And that was some of the legislation I did years ago. And so this is pretty fascinating. What's the liability for a bank if, they exercise something that says pay on death, but they didn't know all the rest of the story? There's lots there, really.
So, Mr. Meyer, before you comment on Senator Case, just to pick up on, what the senator's talking about, I think I'm hearing that you feel okay about putting this bill into the green books, but there might still be work ahead. Is that kind of what I'm hearing?
Mr. Chairman and Senator Case, I will tell you, I agree. I think that there's a lot there that, as the practicing attorney, that I would like to see happen so that there's a lot of these questions get resolved. And I certainly don't do family law, so I don't understand all of that they go through, but having gone through it myself, I look through it and I say that makes sense. But as an attorney that does estate planning and probate, I do think that there are issues that this would help clarify. I do worry about the exposure that the financial institutions, especially in my world, in banks, that they would have. What do they have to do? What do they make sure that we have something now on our forms that says understand this, or we pay attention to, I'm sure every one of them does, the obituaries, but what kind of liability would the financial institution have if they don't see this on there? So I think there are things that can be tweaked into this, but I do say support the notion of it, yes.
Follow-up?
I'll be anxious to see how this. Mr. Chairman, I'll be anxious to see what suggestions there might be and kind of the back and forth.
Yeah. So, Mr. Meyer, thanks for being here tonight. And obviously, it's always the case that we can catch something on the fly. If you spot something and feel like it's going to help it along the way, we stand ready to do that. My sense is, my inclination is that we'll probably move this bill forward and go upstairs, but it's a work in progress, so.
Mr. Chairman, I would agree, and I wouldn't want to slow it down because of that. I just think, there's just needs to be a few tweaks here and there to make sure we know what's happening, and I'll certainly be happy to give you my suggestions as we go through this.
There's always the opportunity to take it into an interim to take a look at it, but very good stuff. Thank you, Mr.
And Mr. Chairman, just
Go ahead, Senator Case.
so this is in the, I assume, the wills and part of the statute, and it doesn't. We don't have the banking statute open here, or all the other connections with pay on death. And I think there is real estate that can be pay on death or something. I know we've really expanded that. So all those instruments are out there, and now we're in essence saying you may have pay on death on the account, but this trumps that. But it's not in your statute, the banking statute. And how does that work? Now does a bank have to say, we got a death certificate, but now we got to know, were they still husband and wife? Are we asking that question? And if they weren't husband and wife, does that come into play? Is there a will that overrides that? I mean, that gets pretty complicated for someone that holds an account or property to try to figure that out. And that's none of those statutes are in this bill.
Yeah, notwithstanding 26125.
Yeah.
Right.
Yeah.
Well, and I will add, Mr. Chairman, and I think Representative Crago is right. It's not like, there's probably two camps of people they're falling into this. The ones that don't want to acknowledge the fact that something has happened, and somebody that just didn't get things done. And that's the problem, is that, you just didn't get things done. And we all are guilty of that at some point in time, of just not getting done quite what we should have quick enough. But this has definitely ramifications. So I'd like to see something go forward with it. But I think Senator Case is correct. This has a lot of impact on a whole lot of different statutes. Transfer on death deeds that we seem to do a lot of. Almost every financial account seems to have a pay on death option now. So,
And just,
Yeah, go
I'm
ahead,
sorry,
Senator.
this,
No.
well, I did a lot of these bills, you know, to make probate easier, cut the lawyers out of the deal. And, but it just seems like now, so say that the payment did occur, the pay on debt did occur, so that money's gone, where the person that should have got the money now has to go to the court, and we're going to try to go back and get the money returned either from the individual or, there's a lot here that'll probably have to get worked out over a long time.
Yeah,
Maybe
good-
not, but
Good discussion. Mr. Meyer, thank you. Stand close by. We might have another question or a thought for you. But let's go to further testimony on Senate File 100.
Mr. Chairman, Guy Bedoin, Department of Health Vital Statistics Services. So I have a couple of comments, and really they're to do with the second, third order effects of this. The proposal doesn't necessarily affect vital records, but the definitions that are being used, you noted that there are other statutes throughout the Green Books. This is the first place that divorce is actually listed. It's not in Title 20, but these definitions, they do help vital records do their job, to issue death certificates to those parties who are entitled. And these definitions are going to help me and my staff and vital records do their job and do it better. So I appreciate that. I just wanted to make that note that this is something that helps us do our job better. And I think that's what we're supposed to be doing with legislation. And for that, I would stand with for any questions that you might have with regards to this and vital records.
Appreciate Vital Records being here tonight. Thank you for that. Any questions? We may have some work ahead that we'll work together with you. So
I think so, but for where we're at right now, we do appreciate
yeah, thank
what's
you.
been published, and
Thanks
this is
for
something
being
that
here.
helps
Really
us do our
appreciate
job.
it.
Thank you, Mr. Chairman.
Further testimony on Senate File 100. Further testimony in the room, Senate File 100. Okay, Judy, is there anyone online tonight that would like to weigh in on this?
you channel anybody in heaven?
Yeah, there we go. Okay, we're gonna close testimony. Committee, what's your pleasure on this bill? Moved by Cooper and discussion. You know, committee, I've got a little bit of discussion just to simply say, and I'm looking at Representative Crago also, we may want to consider additional work in this part of the world as we go forward into the interim. So maybe the three of us, the 6 or 7 of us can kind of remember that and put forth a thought, maybe. Okay. Senator Casey, you had a thought on the bill?
No, Mr. Chairman, I think this could do some good now. I'm sorry, my microphone wasn't on. This could definitely do some good now, help some people, get their wishes more nailed down. But there will definitely be corners where it's not happening, but that already happens now. So the bill in itself does good. Let's just remember that. And so then the question about how it affects the banks and all this other stuff, I think, and the effective date is this July. We don't have a session in between. We'll probably have bills for the next several years that tie back to this, maybe in some areas. I don't know.
Yeah, good thought. Let's work the bill, committee. Any amendments? We won't go page by page. Anything that you caught or saw?
Can I ask just general question about the definitions? This is in Title 2, so it's way up in the front of the Green Books. Are there not other definitions already? Or is this a recodification? It says created, all these definitions.
Yeah, that is,
It seems weird to me that this is the first time we're defining divorce or annulment or.
Mr. Chairman, so I was just as struck by what the Department of Health testified as you are, because I think they were referring to the entirety of the Green Books, that divorced and annulled was not in Green Books. Now, maybe that's not what maybe I didn't understand that correctly, but that's what I understood. So now, whether this definition is applicable throughout the Green Books, that's a different question. But if someone wanted to use it, if it's the only one, then I guess that's their prerogative.
But it does say as used in this section.
Absolutely, Mr. Chairman.
So there is that limit.
Department of Health, any desire to come forth and just confirm or deny what we think we heard? I mean, really appreciate it. Thanks.
Mr. Chairman, Guy Bedoyan again with the Vital Records. So I'm not an attorney, but I did do a search through all of the statutes. Divorce, court reports of divorce and annulment is noted in 35-1-4 to 31-423, which is our statutes for vital records. But I don't even have a definition there. So this one, again, I think I can use it. If anything, I can reference it in rule also, which helps me then, not necessarily this, but divorce person and governing instrument is the big one, where we would go and someone would ask for a specific document, a death certificate, as an example, and may not be entitled to it. That's correct, is no longer entitled to it, and I can use this as a reference, which again, helps me do my job. So I would go back to to you legislators and wherever I can use these, if I have to, I'll go back to rule and use it. But it's always nice to have it right up front. Then there's interpretation. I can at least go back to our AG and say, this is what the statute says. And it, again, makes my job easier. So that's the search I did. Again.
Guy, I really appreciate it. I'm learning on the fly tonight. This is very helpful.
Yes, sir.
Thank you for that.
Thank you, Mr. Chairman. I'll stand for any other questions.
That's exactly confirming, what you thought, and Senator Case is on it. So any further thoughts on that front, Senator Barlow? So committee, back to the discussion on the bill, is there any proposed amendments? Are we ready for the vote?
I think we should tee it up and let it fly.
All right. Judy, would you take roll on Senate File 100, please? And
did we get a motion? I don't remember. Okay, sorry.
Moved by Senator Cooper, I believe.
Great.
Then we're going to talk about Senate File 23 real quickly, but go ahead, Judy. Thanks.
Senator Case.
Aye.
Senator Cooper.
Aye.
Senator Furphy.
Aye.
Senator Schuler.
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there were 5 ayes on this.
Okay, and so that bill passes the committee, as did Senate File 23 earlier. I failed to mention that. And Senator Barlow, nice work to get the bill this far. And we learned a lot tonight.
Thank you, Mr. Chairman. And I assure the committee that we'll visit with Mr. Meyer and a couple other folks. We'll got a lifeline out. And Mr. Crago and I will, Representative Crago and I will try to get to some of those stickier questions and at least maybe not get them resolved, but be able to address them better when Senator Case brings them on the floor. Thank you, Mr. Chairman.
This committee, I think, enjoyed learning about this bill, and we'll be behind you as best we can up on the floor, and on it goes. Really appreciate it, Representative, you coming as co-sponsor. We hope to get it over to you in good shape one of these days. So thanks, gentlemen. Really appreciate it. So, committee, we did not visit about Senate File 23. Does anyone have a burning desire to take this one out on the floor? I would.
I could. I would be happy if you need a backup.
Yeah, I'll help however you want.
And Mr. Chairman, so as a former chairman of Labor Health on the House side, an 8-year member of Labor Health on the House side, actually this came from during my tenure and it's been talked about. So I will be also willing to help or bring it on the floor if you so desire, but I will be there for the bill and the committee as well. Thank you, Mr. Chairman.
I appreciate that, Senator Barlow. We will sure be backing you up on Senate File 100. Senate File 23, I think we all are pretty well versed and can maybe even tag team it. Senator Schuler, if you want to maybe take the lead on it, that'd be great.
Senator Casey.
And Senator Case can jump in, as can Senator Cooper worked during the interim, and Senator Furphy and I can be on standby. Yeah.
You don't want to take 23, right?
It's a little bit past me yet, I think. I'm much more comfortable with you.
Well, thank you, Senator Schuler. Anything else for the good of the cause, committee? Thank you again for carving out time this evening. We'll be right back at it at 7:30 in the morning. So we still have quite a few bills to work, and appreciate all your hard work. Thank you, committee. We are adjourned.